Okay. Good evening. It's 5:41 p.m. where I'm at, and I did some more digging around. This one was a little more of a maze than most subjects, and a lot of people get confused on the facts concerning the First Amendment. Uh, there are people who believe that anything and absolutely everything that you could possibly say is protected by the First Amendment. And I am here to tell you that's not true. Now, then there's the big argument. Well, it should be. Well, that's nice. Say that in a courtroom. Well, Your Honor, it should be protected. Do you think the judge is going to say, oh, well, in that case, you're free to go? Yeah, case dismissed. No, they're not. The judge is going to say, but it isn't protected speech. And that's where we're at legally. So don't even try this it should be stuff. It doesn't work. Now, I gotta start off right away with a video. And it's a good starting point. I was lucky to find this.
The First Amendment protects freedoms of speech, press, religion, assembly, and petition. This sounds straightforward, but the First Amendment is still the subject of continuing interpretation and dispute. So let's look at the freedom of speech, which gives Americans the right to express themselves without fear of government interference. There are a number of categories of unprotected speech, including obscenity, true threats, incitement to imminent lawless action, and defamation. But deciding what speech falls within these categories is difficult. In reaching these determinations, courts often look at speech on a case-by-case basis and consider the context in which the speech was made. For instance, political speech, support or opposition of political figures, parties, and/or policies, enjoys stronger First Amendment protection. If speech is political in nature, no matter how outrageous and offensive it might be, it may still be protected by the First Amendment. So, this gets complicated. The First Amendment protects you from government punishment for what you say in most instances. However, the First Amendment is not unlimited. It protects you from government action, not the action of private organizations or people. Unless you're employed by the government, complaining about your boss could get you fired. Similarly, since social media websites are for the most part private entities, they're the only ones who can police posts on their respective sites. Similar to freedom of speech, freedom of the press allows people to express themselves through publication. This important freedom enables our journalists and reporters to freely report news and stories of public interest. But this also comes with some limitations. For instance, defamatory statements are not protected. Again, though, what constitutes defamation also requires a fact-intensive investigation. In addition, the First Amendment protects our right to peacefully assemble or gather together as a group for like-minded social, economic, political, or religious purposes. The First Amendment also protects our right to protest the government. We are free to sign petitions or even file a lawsuit against the government as well. And lastly, in guaranteeing the freedom of religion, the First Amendment prohibits the government from establishing a state religion or from favoring one religion over the other.
Yeah, it's real important stuff. Defamatory. If you're going to defame someone, if you're going to damage their reputation by saying something defamatory, that's not protected. You can get sued for that. So defamation, you can get sued. Okay. Now, if you put something in print, that's liable. You get sued for that too. See. So you have to be very careful about what you say and how you say it, who you say it to, where you are when you say it, and like it or not, that's just the way it is. Not everything is protected.
The First Amendment to the United States Constitution is a foundational legal provision enshrined in the Bill of Rights, ratified in 1791. It guarantees several essential freedoms, and numerous federal laws and Supreme Court decisions have interpreted, expanded, or limited its application. Text of the First Amendment: Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peaceably to assemble, and to petition the government for a redress of grievances.
There are limits there too. The freedom of religion. If your religion requires human sacrifices, probably not protected. Okay? Just throwing that out there. If it requires you to go out and hurt people, not protected. If it requires you to say terrible things about people that are going to ruin their lives, not protected. Let's see. The freedom of speech, we went over that. Or of the press. Now, there are limits to the press, too. The press can't defame people either. So all the rules still apply to them. But they have a couple of more protections. They can actually say things in such a way as they can say, well, that wasn't a threat, or that wasn't an accusation. If you look at it, that's not what it was. You have to look at it in context, and they can, if they can justify that it was not unprotected, then, then they're good to go. If they can't prove it, and you've got people like the ladies on The View, ladies on The View, that more than one of them has been sued, successfully, for saying things about certain people. So, in fact, a few of them almost got fired for saying things. So, and that's another thing. The Constitution, listen to me, this is really important. The Constitution protects you from the government, not from your employer. Don't ever try to tell your employer, you're violating my civil rights. Don't even bother with that, because your employer is not one of the people that the Constitution protects you from. Now, that's the truth. It protects you from being abused by your government. So, yeah, it's just your employer can still abuse the hell out of you.
Core rights protected by the First Amendment. Religion. Establishment Clause. Government cannot establish a national religion or favor one religion over another. Free Exercise Clause. People are free to practice their religion as they wish. Speech. Individuals can express themselves without government interference or regulation, with certain exceptions, for example incitement, threats. Press. The press has the right to publish information, including criticisms of the government. Assembly. People can gather in groups for protests, rallies, and public meetings. Petition. Citizens can appeal to the government to address grievances or seek remedies.
Now, when you appeal to your government, you have to understand that there are limits there, too. There are certain types of cases that the government is just not going to hear. Period. That's what your lower courts are for. Okay? District courts and such, that's what those are for. So, by government, it's talking about those courts, the court system. You want to take someone to civil court for slandering you, or for defaming you, or printing something liable about you, you can do that. But don't ever try to take a case directly to the United States Supreme Court. It won't work. It just won't work. Not unless it's something so earth-shaking, so world-changing that they can't ignore it. But 9 times out of 10, they're going to say, You got a couple of courts to go through before you get to us.
Major federal laws and doctrines affecting the First Amendment. While the Constitution is interpreted primarily by courts, especially the U.S. Supreme Court, several laws and legal doctrines have shaped First Amendment rights. 1. Federal laws related to free speech and expression. The Espionage Act of 1917 and Sedition Act of 1918 criminalized speech that interfered with the war effort or criticized the government during wartime. Parts later ruled unconstitutional or repealed. Communications Decency Act, 1996, attempted to regulate obscene and indecent internet content. Parts ruled unconstitutional in Reno versus ACLU, 1997.
Okay. Now, what's obscene and what is not obscene, believe it or not, actually depends on where you're standing and who you're talking to. That's the truth. Something that may be considered obscene in this particular area, county, state, be it whatever, might not be obscene, well, anywhere else. But in that area, as far as the citizenry and the government over there is concerned, that would be obscene. So obscenity is open to interpretation, and it can come around to bite you. You can stand in front of a cop and you can swear at him all day long. But if you're in the wrong town or wrong county or wrong state and you're crossing a line, they're going to let you know real quick, and there is nothing you can do about it because you're the one who crossed the line. Now, the Constitution says freedom of speech. I'll say it again. It doesn't mean you can say whatever you want, whenever you want, wherever you want, to whoever you want. It doesn't mean that. It just means that there are protected forms of speech. As long as you stay within those parameters, you should be good to go.
Campaign finance laws. Bipartisan Campaign Reform Act, 2002. McCain-Feingold Act, regulated soft money and political ads. Partially invalidated by Citizens United versus FEC, 2010. 2. Free Exercise and Establishment Clause cases. Religious Freedom Restoration Act, 1993, reinstated strict scrutiny for laws burdening religious practice. Only applies to federal laws due to City of Bourne versus Flores.
Again, that is only a federal law because the Constitution says that you're protected. And again, the Constitution only protects you from your government agencies, like the federal government, state government, local governments, counties, cities, towns, police departments, anybody who works for an office of the government, or be it local or federal. And let me see here. What happened there? There we go. Don't know why that happened, but anyway, we got to fix. So that's the truth now. Protect you from your government, and that's it. Remember that. That's important.
Equal Access Act, 1984, requires public schools to give religious groups equal access to facilities if other student groups are allowed. Key Supreme Court cases interpreting the First Amendment. Religion. Everson versus Board of Education, 1947, applied the Establishment Clause to the states via the 14th Amendment. YouTube video player. Lemon versus Kurtzman, 1971.
Okay, let's Everson versus Board of Education. This is interesting.
Case briefs and so much more.
Not that LSD.
In the 1947 Supreme Court case of Everson v. Board of Education, the central focus was on the government's responsibility to remain neutral in its dealings with various religious groups, and to not support religion or religious institutions with taxpayer money. The case emerged from a New Jersey statute that allowed local school districts to offer reimbursement to parents who sent their children to parochial schools, including Catholic schools with religious instruction. A district taxpayer filed a lawsuit claiming that the statute violated both state and federal constitutions due to religious discrimination. The New Jersey Court of Errors and Appeals upheld the law, but it was eventually appealed to the Supreme Court. The case raised important issues related to the establishment and free exercise clauses of the First Amendment, which are meant to limit the government's ability to promote a religion. Ultimately, the Supreme Court ruled that New Jersey's program allowing children to attend parochial schools, provided they met the state's secular educational requirements, did not violate the Establishment Clause of the First Amendment. By offering general transportation assistance without financial support to the schools themselves, the law was deemed to serve a public purpose without religious discrimination, and was declared constitutional.
Case briefs and so much more.
Now,
LS data.
so they ruled that the children can attend schools other than mainstream schools as long as they could pass the Regents tests and things like that when it came time for exams. Got to keep them grades up, you know?
Created the Lemon Test for determining violation of the Establishment Clause. YouTube video player. Employment Division versus Smith.
Okay, Lemon versus Kurtzman.
Thomas Jefferson famously said that the First Amendment created, quote, a wall of separation between church and state, unquote. Is that how the modern Supreme Court has interpreted the First Amendment? The United States Supreme Court extensively interpreted the Establishment Clause in Lemon versus Kurtzman. Rhode Island enacted legislation providing a salary supplement to teachers in the state's private elementary and secondary schools, 95% of which were Catholic schools. The legislation required teachers receiving the supplement to teach only secular courses also taught in the public schools with the same materials used in the public schools. Pennsylvania enacted legislation directly reimbursing private, mostly Catholic schools for teachers' salaries and instructional materials. Reimbursement was restricted to secular courses also taught in the public schools. In both cases, there wasn't a dispute that parochial schools are an essential part of the Catholic Church's religious mission. Alton Lemon, a state taxpayer and parent of a child in public school in Pennsylvania, and others filed a federal lawsuit seeking an injunction against the Pennsylvania statute on the ground that it violated the Establishment Clause. A 3-judge panel of the district court dismissed the lawsuit. Joan DeCenso and other state taxpayers and parents of children in Rhode Island public schools filed a similar federal lawsuit seeking an injunction against the Rhode Island statute. A 3-judge panel of the district ruled in the plaintiff's favor. Lemon and his fellow plaintiffs appealed to the United States Supreme Court in the Pennsylvania case. In the Rhode Island case, the defendants, state officials, and parents of children in Catholic schools also appealed to the Supreme Court.
Okay, so that's about okay, Davison versus Smith. Go.
The Native American Church combines traditional Native American beliefs with Christianity. The use of peyote in worship is among the traditional Native American beliefs the church follows. The federal government in many states exempted sacramental peyote use from applicable drug laws. Oregon did not. In Employment Division, Department of Human Resources of Oregon versus Smith, the United States Supreme Court considered whether making sacramental peyote use illegal violated the Free Exercise Clause. Alfred Smith and Galen Black were fired from their jobs because, as members of the Native American Church, they had used peyote as part of a sacramental worship rite. The State Employment Division denied both men unemployment compensation because they were fired for work-related misconduct. The Oregon Court of Appeals reversed the agency decision as a violation of Smith and Black's free exercise rights. The Oregon Supreme Court affirmed, and the state appealed to the United States Supreme Court. In Smith 1, the first time the United States Supreme Court considered the case, it determined that if a state could criminalize certain religious conduct without violating the First Amendment, then a state could deny unemployment compensation for the same conduct. Because the Oregon Supreme Court hadn't decided if sacramental peyote use was illegal under Oregon law, the United States Supreme Court remanded the case. On remand, the Oregon Supreme Court determined that Oregon's drug laws didn't exempt religious peyote use, but then held that Oregon's failure to make such an exemption violated the Free Exercise Clause. The United States Supreme Court granted cert to again consider the case.
Okay, so these guys, they went to a church, Native American church, where they used peyote in the church. They do that for vision quests and things. Now, it was illegal. It's an illegal drug. Although it's not actually a drug, it's mushrooms, I guess. But grown under very specific circumstances, like cow poop, stuff like that. Anyway, well, maybe it's not mushrooms. Actually, maybe it's more like a cactus, I think. But anyway, so it was deemed legal by the Supreme Court. However, Oregon said, we don't care because the Supreme Court doesn't run our state. That runs things on the federal level. So now they go back to Oregon and they say, well, we want our unemployment benefits because we're unemployed. And Oregon says, no, not going to do it. How sad is that? Now, it goes back to the Supreme Court. And the Supreme Court says, okay, well, you guys, you got to decide all this stuff out. So Oregon Supreme Court says, okay, fine. It's still not legal. It's not legal, right? But stopping them from using it in their church services, that's a violation of Fair Use Act. So they go to try to get their unemployment. The unemployment office still says legally, I know it's twisted, but this is legally, sorry, you don't get benefits because you were fired from your job for misbehaving on the job. And technically that's true, even though what they did was deemed not to be illegal the way they were doing it. And I know, like I said, that sounds twisted, and you are right if you think so. I disagree with that judgment, but that's the way the law works out sometimes.
1990, government can enforce generally applicable laws even if they burden religion.
Yep.
YouTube video player. Burwell versus Hobby Lobby, 2014, allowed closely held corporations to deny contraception coverage on religious ground.
Okay, you're looking for a company. It's owned by Christians. They say, we don't want our health insurance that we give our employees to cover these drugs because they are against what we believe in this case, drugs that can cause an abortion. That also includes, certain contraception methods and those sorts of things. Not covered by health insurance by some employers legally because they say, well, those people don't believe in it, so why should they have to pay for it? So, yeah. So they're not going to do that.
Burwell v. Hobby Lobby Stores, 2014. Hobby Lobby Stores Incorporated is owned by the Green family. This family had organized its business around the principles of their Christian faith. When the Affordable Care Act, or the ACA, which is sometimes known as Obamacare, was passed, it required Hobby Lobby and other companies with more than 50 employees to provide certain types of preventative care, including contraception. There are exemptions in the law for religious-based employers and nonprofit religious institutions, but there were no exemptions given to for-profit institutions such as Hobby Lobby. The Green family objected to 4 particular drugs that, according to the ACA, must be provided to its employees. The family claims that these particular drugs can cause abortions. In 2012, the Green family sued in federal court, claiming their First Amendment rights under the Free Exercise Clause were being violated. They also claimed that forcing them to provide these contraceptive methods violated the Religious Freedom Restoration Act of 1993, otherwise known as the RFRA. This case made it all the way to the United States Supreme Court. In a 5-4 decision, the Supreme Court agreed with Hobby Lobby and struck down the federal government's mandate on certain contraceptives. According to the court, corporations with closely held religious objections cannot be forced to provide services that contradict their religious values, according to the RFRA federal law. The ruling did not address, however, the Free Exercise Clause of the First Amendment.
So there it is. Your employer, that if they pay for your insurance, there are certain things they don't have to pay for in your insurance if it violates their religious beliefs. I understand it's your health insurance. I get it, but they pay for it. So they foot the bill, they call the shots. Again, it's just the way it is.
YouTube video player. Free Speech Shank versus United States, 1919. Clear and present danger test.
Clear and present danger test. Here's a good case for this.
Well, hey there, welcome back to Heimlich's History. In this video, we're going to be looking at yet another one of your required Supreme Court cases for the AP government curriculum, namely Shank v. the United States. So if you're ready to get them brain cows milked, then let's get to it. So as always, let's begin with the facts of the case. So in 1917, Congress passed a law called the Espionage Act, and its purpose in part was to outlaw any hindrances to military recruitment. Now, this was right smack in the middle of America's involvement in World War I and the draft that just started that year. So a guy by the name of Charles Shank, who was a member of the Socialist Party in Philadelphia, was not a big fan of the military draft. So he brought up a pamphlet which encouraged young American men to resist the draft. In the pamphlet, Shank claimed that the draft was nothing more than intimidation that required resistance, and said that it was really no different than a form of involuntary servitude, which of course was outlawed by the 13th Amendment. And Shank went ahead and distributed something like 15,000 of these pamphlets, after which he was summarily arrested and sent to trial for breaking the law, which is to say, the Espionage Act. And after the ruling was appealed, the case ended up before the Supreme Court. So what was the constitutional principle at stake in this case? Well, it was clear that Shank had violated the Espionage Act, but he argued back that his First Amendment right to free speech was violated, and therefore that section of the Espionage Act was unconstitutional. In Shank's mind, he had every right to protest the war, and if the government silenced his dissent, it would be a tyrannical government overreach. So, was he right? Well, let's look at the decision the court handed down. As it turns out, the court did not agree with Mr. Shank. The court ruled in a unanimous decision that Shank's First Amendment rights were not violated because he wasn't merely protesting the draft. Instead, his words were actively encouraging men to avoid the draft, and that was something different altogether. And at the end of the day, it was not protected speech. And why not? Well, because, as Oliver Wendell Holmes wrote in his majority opinion, the most stringent protection of free speech would not protect a man in falsely shouting fire in a theater and causing a panic. The question in every case is whether the words used are used in such circumstances and are of such a nature as to create a clear and present danger that they will bring about the substantive evils that Congress has a right to prevent. And that phrase, clear and present danger, created a test by which protected and unprotected speech can be measured. Like, it's clear that if you yell fire in a crowded theater and everyone freaks out and tramples each other and maybe gets injured in order to leave, that cannot fall under the protection of the First Amendment. In doing that, you have caused harm to others by your words, which have induced a clear and present danger to their health and well-being. So now let's consider why this case matters. First of all, it matters because it created a very clear standard for the silencing of speech. In this case, Holmes mentioned in his written opinion that the government has more right to infringe upon the right to free speech during a time of war because, quote, many things that might be said in time of peace are such a hindrance to its effort that their utterance will not be endured so long as men fight, and that no court could regard them as protected by by any constitutional right. So the clear and present danger test emerged out of this case to be applied to such situation. However, the clear and present danger test is no longer used, and it has been superseded by the Brandenburg test, which makes a clear distinction between the intent of speech and its likelihood to incite lawless activity. In other words, if it's clear that the speech did not intend to incite lawless action, then even if it is incendiary and offensive, the speech is usually protected. And really what you should remember here is that the Brandenburg test set an even higher bar for the government to clear before silencing speech. Okay, that's what you need to know about Schenck v. the United States. Click here if you want a review packet, which is going to help you get it.
So if you say something, as long as it doesn't incite some kind of action from you or somebody else to cause harm or the threat of harm to somebody else, then it's protected. But the minute people start feeling threatened, and if they can prove in a court of law that what you said could be misconstrued as a threat, you might have a problem.
YouTube video player. Brandenburg versus Ohio, 1969, refined into the imminent lawless action standard.
Now, this one is a little sensitive for some people, but it's important.
The First Amendment right to freedom of speech encompasses one of America's most divisive and hotly debated subjects, the advocacy of violence for political purposes. Does the First Amendment protect politically motivated incitement to violence? Does it matter if the speaker's politics are motivated by hate? The United States Supreme Court considered these questions in Brandenburg versus Ohio. Clarence Brandenburg was a member of the Ku Klux Klan. He invited a reporter to attend and film a Ku Klux Klan meeting. During the meeting, Klan members brandished weapons and made derogatory remarks about African American and Jewish people. Brandenburg also said, "We're not a revengeant organization, but if our president, our Congress, our Supreme Court continues to suppress the white Caucasian race, it's possible that there might have to be some revengeance taken." After footage of this meeting aired on television, the state of Ohio charged Brandenburg with violating the Ohio Criminal Syndicalism Act. The act criminalized the advocacy of, quote, crime, sabotage, violence, or unlawful methods of terrorism as a means of accomplishing industrial or political reform, unquote. Brandenburg was convicted, and he appealed on the grounds that the act violated his First Amendment right to freedom of speech. The state appellate court affirmed his conviction, as did the Ohio Supreme Court. The United States Supreme Court granted cert.
So, if you have an opportunity to say something like that, don't. I mean, unless you're in the kind of company that either doesn't care if you say it, or they believe the same thing you do, because the first time somebody reports it, it automatically could become a hate crime. Don't like it? So what? That's the law. That's simple.
YouTube video player. Tinker versus Des Moines, 1969. Students have free speech rights in schools. Texas versus Johnson, 1989. Flag burning is protected speech. Citizens United versus FEC, 2010. Corporations and unions can spend unlimited amounts on political campaign.
Flag burning. All right. Makes me angry. It does. Whenever I see it, I get really, really angry. And it is my view as an American, you shouldn't be burning my flag. Now, that's how I feel about it. Now, as far as the Constitution is concerned, Constitution doesn't care. Not about that. What the Constitution says is those people have a right to express themselves, and if they're going to burn the American flag to do it, then it's not violating the Constitution, and it's protected. It's protected. So it is illegal for them to get any sort of legal trouble. If they can't be arrested for it, they can't be taken to court for it, they can't, none of that. Can't be written a ticket for it. Unless they're burning something in a place where they shouldn't be burning something and under certain circumstances. But then that would be the same for a burn barrel fire. If you've got a burn barrel and you're in New York City and you're in the middle of Times Square, right in the middle of the road, and you set a burn barrel up on fire, well, you might get a ticket, okay? But it is protected to burn the American flag. I hate it. I do. But that's just the way it is.
Press New York Times versus Sullivan, 1964, established actual malice standard for libel involving public officials. New York Times Co. versus United States, 1971, Pentagon Papers, reinforced prohibition on prior restraint.
Prior restraint. If you're out filming, recording, video recording, say a police officer in the performance of their duties, and you're far enough away that you are not a threat. You are not, you don't have any sort of items of concern. You're just a camera. If that police officer takes any measures to stop you from being able to record that, then that is called prior restraint. And that police officer might be in trouble, although I doubt it because a lot of departments do tend to protect their own. So don't count on it.
Assembly and Petition NAACP versus Alabama, 1958. States cannot compel groups to reveal member lists. Freedom of association. Adderley versus Florida, 1966. Limited right to protest on certain government property. Snyder versus Phelps, 2011. Protects even offensive protest speech at public event.
Okay. NAACP versus Alabama. You cannot be compelled to tell authorities who else is in your group. You can't say, well, we have a 1 million member organization, and they can't say, well, give us a list of all the members so we can go and, approach them too. You don't have to give it to them. You don't have to give it to them at all. So that's important to know. That doesn't mean that they can't cause you extra problems for it. All that means is it's not legal for them to prosecute you for that. Okay, but a police officer or a savvy prosecutor can find a reason to prosecute mold. So pick your battles wisely.
Limits on First Amendment rights. Even though the First Amendment is broad, there are categories of speech not protected. Obscenity, Miller versus California. Defamation, libel and slander. Incitement to violence, Brandenburg test. True threats. Fighting words. Commercial speech,
Fighting words. If you challenge somebody to a fight, if you go, hey, I'm gonna beat you down. I'm gonna beat you down right here, right now. Come on, let's go. Those are fighting words. Those are not protected. Those are not protected. Don't let anybody tell you any different. They're not protected.
protected. Child pornography. Time, place, and manner restrictions must be content neutral and narrowly tailored.
Okay, time, place, and manner restrictions. Okay, let's say you walk into a prison and you want to take some pictures of the inside of the prison. Well, the time depends on, is it the time of day when people are allowed in the prison? Or is public access closed for certain hours? Excuse me. Now, the manner, the place is where in the prison. Now, obviously, they're not going to walk you through the cell blocks and say, here, take pictures of all these prisoners and all these bars and whatever else happens to be in there. That's a bad place to do that. Now, in a manner in which to do it, if you are overly aggressive, you walk past restriction lines, you disregard any sort of actual law that does govern that sort of thing, the manner in which you are doing that, you can get in trouble for that. That's not protected. All right? So those are things to remember.
Application to the state's 14th Amendment Incorporation Doctrine. The Supreme Court has applied the First Amendment to state and local governments through selective incorporation. Summary chart. Religion. Establishment. Free exercise. Lemon versus Kurtzman, Smith, Hobby Lobby. RFRA, Equal Access Act. Speech. Free Speech Clause. Schenck, Brandenburg, Tinker, Citizens United.
It's all those
Campaign Finance
videos
Laws,
up there.
CDA, partial. Press. Free Press Clause. Meade versus Sullivan, Pentagon Papers. FOIA, indirectly. Assembly. Right to assemble. NAACP versus Alabama, Adderley. Local permit ordinances. Petition. Right to petition. Snyder versus Phelps.
Now, these things, I put them in here so that if you want to, you can grab a pen and some paper, or you can put it in a notepad or wherever it is, whatever you want to do with it, and look things up yourself. Important information, really important information. So if there's important information that you just might need to know one day, go find out. If I can do it, you can do it. And if you would please, feel free to comment, give us a thumbs up, share our content, follow. Happy to have you. And it really does help out. So at this time, I will thank you for your time. And I will say, God bless you. God bless America.